Alex here with part 126 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We now go into the writ petition case that's been filed in the lower court. I think we left off with the Secretary of State's response indicating that all they wanted was for the law to be complied with and that they were not going to take a position in defense of my ex or in my favor. They specifically stated that pursuant to the Nevada Supreme Court, it was my ex's obligation to, on her own, prove that she was actually a victim of DV. And the only role that the government had to play in that process was to comply with whatever order the court made with regards to ordering her to, or not ordering her, or with regards to ordering or accepting an order to turn over her fictitious address. And I don't even believe that the cancellation of the fictitious address was at issue, though I will state that they did eventually cancel the fictitious address, and it is entered into this case through an affidavit. The reasons why I can't fully remember now, but it will come up in the series and we'll talk about it at that time. I want to mention that at this point in time, my mindset going into preparing what is called a motion for judgment on the pleadings was mostly positive, but at the same time, I do remember having some anxiety over that hearing. So I remember thinking, yeah, this is how the law is supposed to work. I should be able to get a judgment on the pleadings in this case because my ex hasn't filed a response as ordered. However, at that last hearing, the only thing that the judge seemed to care about was the fact that I was filing too many papers. And I know at this point in time, I didn't have that same judge, but I really didn't know if all judges were the same. In fact, I kind of have this instinct that during the first several years of my case, I assumed that all of the judges were mostly like District Judge Chuck Weller. I didn't think that they were exactly like him, but I thought for the most part that's how they operated. And this is not an opinion that starts to change until much, much later when I have had more experience with more different judges. So I think at this point in time, we should just go ahead and take a look at what I have filed. Here we have my motion for judgment on the pleadings. Going into the first paragraph, it's standard introductory paragraph. I identify myself to the court as a petitioner, appearing in proper person, which means I don't have an attorney, and I state that I'm filing a motion for judgment on the pleadings. Before I go into this document, I do want to mention something. I have a video on motion for judgment on the pleadings. Go ahead and take a look at the video if you want to learn more about it. I do want to talk a tiny bit about how defaults work in writ petitions. From what I have read, they don't. This is a fuzzy, very fuzzy recollection, and in fact, it's probably going to be in this document. But the Supreme Court, I believe, I don't think it comes from a statute, though it might. There is some cases that state that a court cannot issue a writ on the default of an opponent. And this doesn't mean that you don't have a very strong likelihood of winning your case when your opponent doesn't respond. It just means that the approach that the court takes is different. With a default, you actually get a filing from the clerk of the court, and the clerk of the court files the default, and then the judge can look at that and they can give you what you're asking for based on that alone. They don't have to read through your complaint or your petition and analyze whether or not the law's in your favor. They can just say, well, they defaulted, what do you want? And that's what you get. With writ petitions, they can't do that. There is no such thing as default, but that doesn't mean that the judge can sort of argue your opponent's case for you. They do have to review the petition, they do have to analyze the law, and they do have to assume that the facts that you are stating are true. They can't just say, well, I, as the judge, just don't believe you. Any facts that you've alleged, without your opponent there to controvert those facts, they should be assumed true. I don't see why this wouldn't occur. So my sort of thought process here is that the only way that you can lose a writ petition that's not opposed is if you yourself are asking for things that aren't available to you under the law. So with a default, none of that's the case. They just say, okay, your opponent defaulted, you win. With these writ petitions, they still have to go through and read what your allegations are and what laws you are alleging entitled you to the relief to make sure that those things are actually true. And then if they are true, you're supposed to win your case. There shouldn't be any sort of I guess you could say speculation by the judge, or even the judge shouldn't even be sort of furthering any arguments against you. It should just be a very cut and dry, one-sided analysis of the petition. So there is a distinction there. I know I just spent like probably 5 to 10 minutes on that, and it might have confused you guys, but I do want to make sure that you understand that there is a distinction between winning by default and winning because your opponent hasn't controverted the allegations that you've made. Those sound like the same thing, but they're not. Because sometimes the allegations that somebody makes, even when uncontroverted, don't entitle that person to relief. This is not usually something that occurs when a lawyer is involved, but it's something that can occur. And this is something that's much more common when you're representing yourself and you don't have an attorney. So anyway, definitely take a look at the video, Motion for Judgment on the Pleadings. I think it's actually just called Judgment on the Pleadings, and you'll learn a little bit more about that. What I'm asking the court to do is to just make a ruling based on the paperwork that's been filed. I'm asking the court to just do this now and don't make us go to an evidentiary hearing. And the reason why is because my ex hasn't filed anything in response. So she's not controverting anything I've alleged. So there's no point to a hearing. Anyway, let's go ahead and go through it. Factual background: number 1, I filed a petition. Number 2, the court entered an order requiring responses within 20 days. Number 3, I served notice of that order upon both my ex and the government. Going into the next assertion, the government filed what amounts to a non-opposition for the most part. All he's asking the court to do is to enter any directions as clearly as possible and in accordance with the law. My ex has not filed any response at all, nothing. Legal analysis. So the court ordered responses to the writ petition within 23 calendar days. I put a little footnote here because I wanted to indicate that those additional 3 days came from most likely a court rule. Let's take a quick look. Yeah, NRCP 6 subsection E, which, by the way, guys, I'm pretty sure this has changed. So, I mean, don't just assume that this still applies. If you want to learn more about that, watch the video Computation of Time. In any event, the writ petition within 23 calendar days of its July 1st, 2013 order. Although the law states that mandamus cannot be granted by default. Okay, so this is what I talked about earlier. It's not just a Supreme Court opinion, it's a statute. NRS 34.200 forbids granting mandamus by default. That doesn't necessarily mean that a hearing on the instant petition is mandatory. It just means the court can't enter it by default. Reinforcing this argument is another case, Department of Motor Vehicles versus Roble. And in this case, somebody failed to answer the petition, and the district court granted the relief requested, even though the opponent didn't respond. That doesn't really count as winning by default because they analyzed that petition. And it states right here in bold that the case shall be heard on the papers. Just because no answer is made doesn't mean the court can't do anything. The court can do something, the court should do something, and the court should do whatever it is that it needs to do based on the papers of the applicant. That's basically what I'm stating here. Right down here at the bottom of this case, they clearly state that the district court considered the evidence and granted the relief requested. As the petition was heard on the papers, it was not granted by default. And this is something I put in bold here to let you, I was worried that this judge wouldn't understand this. Just because a petition was heard on the papers doesn't mean it was granted by default. So this was a case, it's a great case to use here because the government argued, hey, you can't do that, it's not fair. And the Supreme Court of Nevada piped in and said, no, there's a difference between having your papers heard and not getting a hearing and winning by default. It's not the same thing, even though it seems like it to some people. And even the government in this case was confused by that. Moving on, as long as the merit, okay, and here's the key, guys. It's not considered an entry of judgment by default as long as the merits of the petition are considered. So nothing in there requires a hearing. It only requires that the merits are considered. That's all. And you can consider the merits of something without holding a hearing. That's completely within the court's power. It's totally possible. My papers are based on Falcone v. Secretary of State, under which the burden of proof is on my ex by clear and convincing evidence to establish that I'm a perpetrator of DV. Because she's failed to respond, she's failed to meet her burden. It's that simple. I don't have to prove anything. She does. It's her job to prove that these things are true. If she doesn't want to do that, she loses. Moving into the next section, we got my declaration under penalty of perjury, which states that all the facts alleged in this document are true and correct. We go into my Rule 5 Certificate of Service, which states that I've served this document upon my ex's attorney, upon my ex, and upon the government's attorney. Going into the next document, here we have a request for submission. If you want to know more about these documents, please take a look at the video request for submission. In this video, I state how this little piece of paper works, and I also clarify that this is a paper that's not even required in every single jurisdiction in Nevada. It's only required in 2 or 3. So it's totally possible that you're in Nevada and you still don't even need to use this. Definitely watch that video. Certificate of service indicating that this specific document was mailed to my ex and the government. Going into the next document, and this is the order transferring case. So I talked about this earlier in the series, guys. This judge, which is District Judge Patrick Flanagan, invokes the one family, one judge rule to transfer this case back to my family judge. So this is a case that originated in Department 11. The district court's decision dismissing the petition for judicial review was entered in a different department. This one was basically entered by District Judge, I think his name was Stephen Kasach. By the way, he's retired now. I think he still works as a senior judge, though. The petition was denied. I filed the petition for writ of mandamus in the Supreme Court of Nevada, and an opinion was published by Justice Cherry. Going into the next paragraph here, I filed a petition for writ of mandamus in this court, which was randomly assigned to this judge. This judge then cites Local Rule 37, subsection B, which provides that all cases involving any of the same parties or their children shall be assigned to the original department which first dealt with the parties. This is a rule that comes from what people call the one family, one judge rule. If you look at my video on that topic, you'll learn more about that rule. The clerk of the court mistakenly docketed this case as a new matter and randomly assigned it to this department. It is actually correctly docketed as a new matter. That's correct. But it should have been assigned to that judge. And I'm going to go more into this, I think, later in this video. Actually, it might be the next document. We'll take a look. So it's ordered that the clerk shall transfer this matter to Department 11, District Judge Chuck Weller, for all future proceedings in accordance with the Nevada Supreme Court's opinion in this matter. Going into the next the next page, we have Certificate of Service under Rule 5, which is the judge or the judge's employee stating that this order was mailed to both me and my ex. He didn't mail this to the... Okay, he didn't. He provided electronic service to the government. Next is the supplementary points and authorities regarding the jurisdiction of the family division of the district court. Okay, so this is what I was going to talk about. I'm glad to see that it is in this video. So one of the first things that I thought when this case was transferred back to my family judge was, hold on a second, this is not a family case. A petition for writ of mandamus is a special proceeding. It's not a child custody proceeding. It's not a divorce action. It is not a domestic relations matter. It's completely different and completely outside the purview of the family division of the district court. Something is wrong here. So first thing I want to tell my viewers is, rather than me jumping the gun and screaming, calling foul, and saying, hey, I don't want the case in front of this judge, I did some research. I went and did some research, and I looked at some case law to see if it was within this judge's power to hear this case. My main concern was that this case would be invalidated if the district judge ruled in my favor or against me, but I didn't think that would happen. I was worried that I would win this case and that at a later date, my ex's attorney would say, hold on a second, this is a family judge. He doesn't have the power to enter writs of mandamus. He doesn't have the power to issue those writs. And so therefore, Alex, great job winning that case, but too bad, so sad. I'm going to get this vacated because this judge acted outside the boundaries of his subject matter jurisdiction. This was my concern. So I went and I did some research to find out whether or not he had the power to even preside over this case. At first blush, I was concerned, and this is something I state in the first paragraph, that the family division of the district court lacks the subject matter jurisdiction to issue and grant a writ petition. If you guys want to learn more about subject matter jurisdiction, please watch the video. Subject matter jurisdiction, it's a serious issue. This is one of the things that you can get reviewed on appeal even though you haven't objected to it, because it goes to the power of the judge to even listen to you. It's very serious. It's not the same as personal jurisdiction, which can be waived under certain circumstances. Subject matter jurisdiction cannot be waived. You have to know that the case that you've brought to the particular judge is within that particular judge's power to hear, because if you don't do this, it can be vacated. You can end up wasting all of your time and money for nothing, and it can seem very unfair to people, but it does happen. So I go into the next section here, which is legal analysis. And I did my research and I found out that this was actually discussed before. This is not something new. The case is called Landreth v. Malik. And in 2009, the Supreme Court of Nevada held that the family division of the district courts does not have the jurisdiction to hear any of these cases. They cited a statute, 3.223, stating that the family division cannot preside over any cases that are outside of the boundaries of that statute. If they do this, there is no subject matter jurisdiction, and that decision is void. Now, luckily, I guess you could say luckily, I'm not really sure I have an opinion one way or the other. There was a rehearing on this issue. And 2 years later, the Supreme Court of Nevada changed their mind. In 2011, they reheard Landreth v. Malik, and they decided that the statute, while it does not give the family division of the district court's jurisdiction, that same statute violates the Constitution. In Nevada, the Constitution does allow a district judge to preside over any sort of case. So you could read more if you want to find out the details as to how this occurred. But because that statute is in conflict with the Constitution, the statute is basically being disregarded. And the legislature just does not have the power to limit the jurisdiction of a district judge in the manner that they did. So family division judges can and do hear non-family division cases. It does happen. It's not that common. It doesn't usually occur. It's pretty rare. But when it does occur, it is allowed. And in this particular situation, I wanted to let the judge know, District Judge Chuck Weller, know that he did have the jurisdiction to sit and preside over this case. I didn't want him to ping pong it back because I wasn't sure what he was going to say. And I just wanted to file this to let the judge know. Now, in hindsight, should I have done that? I have a different position now about filing extra things. I typically don't think it's a good idea. And I'm not sure that I would have filed this. Maybe I could have reached out to my ex's attorney to ask her if she would mind me filing it, or to ask her if she would mind a joint petition on it. But at the same time, she hasn't filed anything in this case. She hasn't made an appearance. So maybe it's something that I could have talked to the government about, to Kevin Benson about. Maybe we could have worked out some kind of a joint brief that we could have filed just to let the judge know. But this is not something that I typically think it's a great idea to do. I don't think that you should just jump up and file stuff all the time, anytime, because you're concerned that the judge isn't going to know what he's doing. And it's just because that the system wasn't designed that way. The docket wasn't meant to be bloated by all kinds of extra things. And there are remedies available. If the judge does mess up, you can go ahead and get those remedies corrected on appeal. Still, even though I can understand why I did this, which was I didn't want to waste any time, it was urgent to me, I'm not sure that it was a great idea to do this. And in fact, I would recommend that anyone here, before they file supplementary briefings out of the blue like that, I'd recommend that they ask permission first, or in the alternative, that they do some research and determine whether or not that's something that they can even do. Another thing that I could have done instead was I could have filed a motion for leave of the court to file a supplementary briefing on the jurisdiction. And then I could have attached this as an exhibit to that motion. And then the judge would have probably looked at it and he would have said, nah, it's okay. I understand what you're trying to say. I can preside. That might have been the safer way to do it. So anyway, I'm going to go ahead, and these are just some thoughts that I have, guys. I'm trying to get you guys to think. I'm not necessarily trying to tell you guys what to do. This is a channel that doesn't tell you what to do. This is a channel that gets you thinking on your own. I'm going to move on to the next page, which there is none. So I'm going to go on to the next document. Here we have the Notice of Academic Advisor's Affidavit concerning child support. Okay, I was talking about this before. I knew that something like this was filed, but I didn't know when it was filed. So a number of times I've talked about the issue of weekend classes, night classes, online internet classes, summer classes, winter semester classes, and how and when they are available for my degree. This came up in the previous hearing. Anyone here who has seen that hearing video would know that this was actually one of the issues that drove me crazy. So anyway, I went and met with my academic advisor, and he, I'm going to just skip through this. We've already gone through Rule 5. We've already gone through lists of exhibits in the past. Exhibit 1, I'm going to go into the document itself. Here it is. This, isn't this it here? Yeah, here it is. Dr. Michael Laverington. He declares that number 1, he is, okay, so I've gone through numbers 1 in the past. So this is just him stating he's over the age of 18, not a party to the action. Number 2, he is employed as a lecturer with the University of Nevada's College of Engineering. Number 3, that he is my academic advisor. Number 4, that I am attending 3 400 level computer science and engineering classes and 1 200 level circuit classes. And that I am a full-time student and that I am in attendance, and that my attendance issues are a result of being compelled to attend a trial. Wait, hold on a second. That Alex Falcone's attendance issues as a result of being compelled to attend a trial may cause a negative or adverse impact on his performance or grade in his class. Oh, yeah. So this is him stating that I have to. Why does it say trial, though? My attendance issues as a result of being compelled to attend a trial may cause negative or adverse impacts. Okay, so maybe this is me just trying to say that if I have to go to trial, it could cause an issue on my greater classes. Maybe I'm using that to try and get a ruling from the judge on the papers rather than a second hearing. That might be why I'm saying that. I'm not sure though. Next section here is that weekend classes, night classes, online internet classes, summer classes, and winter semester classes are unavailable for me because the specific classes that I'm taking to graduate do not offer these alternatives. And that's kind of the whole point of this affidavit. Number 8, that he's read each and every allegation in this affidavit, and to his own personal knowledge, he knows it to be true. So this is something that's pretty awesome, is that this is a professor and academic advisor, and he stuck his neck out for me, and he signed this affidavit. He checked with the university. They sent it to their attorneys. They read it, and they said, yeah, this is totally fine. You can go ahead and sign this. Everything in here is true. None of these classes are available to me. So this is, I think, one of the most wonderful things that he could have done. I really strongly appreciated him doing this. I sent it to the judge. I thought the judge would care, and the judge doesn't care. This is one of the things that's crazy about this case is you can make yourself as extraordinary as possible. You can go and do as many things that other parents don't do as you possibly can. You can put in all the groundwork. You can try your hardest, and the judge doesn't care. And this is one of the things that I think is specific to just this judge. I think other judges would see this and they would do something about it. This judge, he's just one of those judges who decides this is what I'm going to do, and I don't care what it is that you're going to say to the contrary. And I talk about this problem, this wrong-headed approach to analyzing a case in the video Conclusions Before the Facts. And I also talk about this problem in the video Meta Rulings. Going into the next document, we have the request for submission, and I think this is the request for submission of that brief. Let's see here. Right, so I am submitting to the court the motion to modify child support, the opposition thereto, the order to file financial disclosures, both financial disclosures filed by my ex and myself, as well as the minutes and the supplementary points and authorities that I filed. This is a document that I've again gone over several times in the past. If you want to learn more about the request for submission, please watch the video on that topic. Rule 5, Certificate of Service, indicating that this document was served upon my ex's attorney. And that's that. Going into the aftermath, I filed, it looks like 1 motion, 2 requests for submissions, a notice, and a supplementary. Those were all free filings, yeah, because that motion wasn't filed in my child custody court, so that's a free filing. So I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney has stated that she's not going to put any effort into the writ petition case, so I'm going to set the motion for judgment on the pleadings and the request for submission at $0. The order transferring case by the judge at $0. The supplementary brief was filed in the child custody. No, it wasn't. It was filed also. Okay, so that's $0. So it looks like the only 2 documents filed in the child custody case are a request for submission and a notice of academic advisor's affidavit. Maybe she would have put more time into that if the hearing hadn't occurred, but the hearing had occurred, so she probably would have very briefly skimmed it. I'm not even going to put 5 minutes on it. I'm going to just say 0. So that's going to come to $0 in attorney fees for my ex. The government's attorney did not file any documents, so he incurred $0 in costs. He would have reviewed the motion for judgment on the pleadings, but I don't think he would have cared because it's not asking for anything against the government. Maybe 5 minutes time for that. Both requests for submissions, he's only going to see one of them, so I'm going to say 5 minutes for that. The order transferring by the judge, he probably put 5 minutes into that, but who cares? I mean, all it's doing is moving the department from one to the other. So we're at 15 minutes so far. The supplementary points and authorities, I mean, he doesn't have to take any action on it. All I'm doing is saying that the judge can do what the judge is supposed to do. So I'm going to say 0 for that. And the other 2 documents weren't even filed in his case. So we're at 15 minutes for the government at the rate of $250 is going to come to $62.50 for the government. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.